Hey guys, what is up? It's Dusty here, and welcome back to another crypto live stream. I just drove about 1 hour and 45 minutes purely so I can get this content to you guys as quick as possible. Of course, I was actually already on my way because, as you can most likely see, the news just broke out about an hour ago. And what just happened is breaking. The SEC has filed an emergency motion for a discovery conference regarding Slack communications. They seek order compelling Ripple to search and produce relevant communications between Ripple employees on Slack. Once more, guys, it is not me making a clickbait here. It is called an emergency motion. That's exactly what we put down there. It's an emergency update. It's an emergency motion. All right. This is the main lawyer, which we get all the information from. Once more, if he says breaking, I say breaking. He says emergency, I say emergency. That's what we do. An emergency, however, in this specific regard, is not necessarily bad. So I haven't read it just quite yet. I just came in, started the live stream, and I just see it's only 3 pages though, guys. So we can quickly go through this and see what's going on. Oh, you guys are saying the senators just agreed. What? Wait a minute, guys. If the senators did agree, that's more important than everything we can cover. But XRP Pioneer, which amendment did they agree on? By the way, if you're wondering what they're saying in the comment section, the senators, if they agreed on... Oh, let me quickly see. Can you show us where you got that from, XR Pioneer? While you are telling us where we can find it and what amendment they agreed upon, go to Twitter. Okay, oh, damn, I'm a little bit confused now because I wanted to quickly cover this. Let's quickly check out if the guy is actually not lying to us. Let's check out the notifications because that is even more breaking news out of everything. Can you tag me over on Twitter, please? Guys, you don't understand. If the senators just agreed on something, that's one of the most important decisions for crypto in a very long time. So if that happened, we have to watch it. I don't care about the breaking news lawsuit update. This is 50,000 times more important. So please, let's confirm if... Can you guys actually check and help me check out? I'm looking on my... okay, let me quickly see. Senators vote... I'm having a blank a little bit. Bill. What's the freaking infrastructure bill? There we go. Infrastructure. Okay, let's quickly see. I just see 1 day ago, 5 hours ago. Final vote approaches. Does anybody have a conclusion, or is this just another? You tagged me. Rob Portman. Okay, I'll check it out. Rob Portman. Sorry for actually for putting it up like this, but this is more important, guys. Trust me when I say that. Okay, so Rob Portman, 11 minutes ago. Okay. I'm pleased to announce that Senators Warner, Toomey, Sinema, Loomis, and I, wait a minute, that's really confusing, have reached an agreement on an amendment to clarify IRS reporting rules for, okay, wait a minute. Okay. We have reached an agreement on an amendment to clarify IRS reporting rules for crypto transactions without curbing innovation or imposing information reporting requirements on stakers, miners, and other non-brokers. So this is a mix, right? Because I'm seeing now this is the mix from the Warner. This is the two amendments kind of mixed together because Portman now is making it seem as if... Wait a minute, so there's a new amendment then which came in, or they just came to an agreement potentially, right? Because but then what amendment? I guess this is good, guys. I'm thinking this is boom time. Let's see our trade. I guess we have a trade open. Maybe we should actually change the leverage a little bit, go even more bullish, because this is juicy, guys. You can't. Yeah, this is really good. You know what? Just for you guys, I'll open a little small long here. You know what? Let's try it out. Let's do something. I know it's going to add to it, but let's just do a long 5 times. Let's go for market. Let's go. I'll put a little bit in for you guys. Let's put in. Oh, I don't even. This is UCT. Let's put in I don't know how much there's in the account still. Let's open $1,000, 1,000 XP worth. Can we do that? There we go. Order value $800. Let's put it in. There we go. I think it added to it, right? I think so. Yeah, liquidation price is 60 cents now. Yeah, that's a hefty one. That was pretty fun. Let's see if this works out. If it doesn't work out, it doesn't work out. But an agreement is huge, and I'm not sure exactly. Okay, so you guys explain it to me now. Guys, let's go 2 steps back, all right? And make sure you press that like button. I did a lot of work to get this to you guys as soon as possible. You guys saying, look at Rob Portman, we have it open. So, for the last couple of days, one of the most important things for crypto was being discussed. I made like 10 videos on it because of the importance, and there was basically an infrastructure bill in the United States. That basically means let's say senators are basically proposing an idea on how they're going to be funding certain pieces of infrastructure in the United States. It's often a very big deal because we're talking trillions of dollars, and within this infrastructure bill, they basically put different ways of getting tax money. And one of the things which they put in there was how they were going to tax crypto, or at least get some money from it for their proposed infrastructure. Now, what this small little rule inside of it did, though, was actually propose an idea of how crypto would be classified for the broader world. We all thought this would be pretty bullish on XRP, but would be pretty bad for all proof of work, proof of stake, and everything because of their definition of a broker. They literally made it look as if a broker was basically everybody who basically gave out crypto to a certain degree or handled crypto. It's not officially like that, but it was basically almost everybody. I should maybe change the title and picture here as well, because I'm going to do another, I guess, video on the Ripple part. I might just give 2 updates on this separately later today. This is more important than everything we've ever seen, all right? So don't worry. Jerry Brito on Twitter has more detailed explanation. Okay, I'll get into it. So that was basically the situation. They had a really broad view of what a broker was, and that would really incriminate every person out there. I mean, proof of stake operators, node operators, I guess everybody out there that is even an exchange, not an exchange, doesn't really matter. Almost anybody out there, all of a sudden had to put up a lot of different tax requirements, or mostly just reporting requirements that were not possible. If you were the starter or the foundation behind a decentralized exchange, or the smart contract, I guess, owner, or the one who proposed it, or the person itself, I guess the smart contract maybe itself, I'm not exactly sure how that would work. But they all had such heavy tax reporting requirements that it would not be possible, that entire crypto would fall because it would not be possible. And so they had a couple of amendments. There were 2 different parties which had different amendments out there. And right now, one of the amendments was kind of negative because it would basically exclude proof of stake. At the start, it would only exclude proof of work, but later on, it would exclude proof of stake, exclude proof of work, but mostly include still a lot of other things. There was this other amendment, though, by Loomis, that would actually exclude most of the important things. Yet what we wanted was one that would kind of include a couple of things like exchanges. Yet in the wording that Rob Portman has put up here, I'm thinking they actually came to a pretty good conclusion, which most likely is just that the tax requirements here are just for parties out there that can do it, like, for example, exchanges. But let me quickly see. You guys tag me on Twitter. I see here Rob Portman, but I've already seen that. Anurag has tagged me. Okay, Senator Rob Portman, Senator Rob Portman, Senator Rob Portman. You guys all tag me under the same man, but you guys are saying check out somebody else. Let me quickly see here. You guys are saying check out. I have to change the title of the video real quick. Emergency update. Bill just passed. Now, I'll call it something different. Most important crypto regulation. Alright, something like that. Let's quickly see. Stay positive. I am positive, actually, because I don't know where the negativity is. Guys, where are you watching from, by the way? You're all saying you tagged me on Twitter, but I'm not seeing it. I'm only seeing Rob Portman. You said check out Jerry Brito. And also, guys, big shout out to XR Pioneer for telling us that it was actually live. Big shout out to you, my friend. You were completely right. I'll check out Jerry Brito. All right, Jerry. Let's go for it. Jerry Brito. I don't know exactly who's Jerry Brito, but Jerry Brito. Tin Quarantino? Is this really him? I don't know who he talked about, man, because I'm looking through my notifications right now, if you're wondering, by the way, but I don't see. Wait a minute. So where's it supposed to be? Because we're only seeing Rob Portman, but this is actually a really small explanation. Is it under Rob Portman's tweet? Is that where it is? Let's quickly check it out. Maybe somebody's put it up down here. Shout out to all the senators that worked hard for the crypto industry. Let's type yes. Yeah, this is pretty cool. Just checking you guys out here. Please could you specify validators? Where can we find it though, guys? Once more, I did so much research on this, yet some things I just still do not understand, because if you're recording, things become a lot more difficult. But conclusion is, the two amendments that were proposed have actually kind of merged as it currently stands. At least that's what it's looking like. Yet we have to look what exactly the conclusion was. Okay, let me type it in here. Infrastructure Bill 2021 breakdown. 1 hour ago, the Senate. There we go. Oh, now things are making sense, guys. Things are making a lot of sense to me. Oh, wait a minute. I'll show you guys some stuff that I have here. All right, don't worry about it. I have some stuff to share. Okay, so a little bit earlier, right? Because you've seen this article here over on Reuters. U.S. Senate Democrats unveiled details of the $3.5 trillion follow-up bill. I already saw, I was liking things on Twitter because that's what I do to kind of prepare for videos. I saw Senator Loomis put this up, right? 3.5 trillion. I was like, why did she do that? What was going on right there? That has to do with this bill that was just proposed as well. Holy smokes. Okay, let's see here. The first bill, which sits atop Democratic President Joe Biden's domestic agenda and includes $550 billion in new spending on roads, bridges, and internet access, cleared an important procedural hurdle late on Sunday when the Senate voted 69-28 in support of the provisions contained in this 2,702-page plan. That's also the problem right here, by the way, of these infrastructure plans. They are usually thousands of pages, which is why the majority of these bills go through without all the senators being able to read every single amendment or final bill, I should call it. By the way, guys, if you're watching right now, there are 700 people watching. We only have 100 likes pressed. Let's get to at least 250. It doesn't cost you any money. It doesn't give me any money, but it makes the live stream perform just a little bit better. It helps with the YouTube algorithm and puts a smile on my face. So why not, right? That's all I'm trying to say right there. Steve says nothing has passed. You sure about that, my friend? I think you're actually right. Wait a minute. Wait, let's actually wait, I'm a little bit confused now, okay? Because what he's saying, nothing has been passed. Wait a minute, this could actually be they came to a conclusion on oh, wait a minute, guys. We have to go do a step back here. Wait a minute. Duck Bob and the other guy, let's quickly see. I'm not sure exactly who it was. You guys are right. You guys are completely right. The final vote is going to be in a couple of days from now. They just came to a conclusion about, okay. They just came to a conclusion. Okay. Most important. Okay, I get it. They just came to a conclusion about a proper amendment. The two parties, which both had a really important amendment outstanding, they came to a conclusion about what amendment they would want. Crypto Regulation Amendment. All right, I'll change the title a little bit. Tomorrow's the vote, I believe. Yeah, I get it, guys. I get it. Okay, sorry for half of the misreporting, I guess. But that's because I'm also finding all this stuff out, you know? I'm looking at it with you guys. I wanted to start talking about the emergency SEC update, but I guess we'll do that in just a second. I'll also make separate videos, okay? Don't worry. I'm just so excited because I don't know, man. All right, you know what? We've actually gone for a little bit of a crazy overkill trait then. I thought it was passed, but if you're wondering right now, our trait is open at you guys can see it. We have about $4,500 in value. 6,200 XRP, about $1,000 margin, and that's because we upped the leverage a little bit. Yeah, can't really complain. Right now, $550 worth of profit, aka 50%, because once more, our margin has gone up significantly. Ooh, that's about to be really interesting. Also, funding rate is up quite significantly because people are extremely long right now, and as you can see, that's also the trend which has been going on. Ooh. Tristan is late to the party. You are missing some interesting stuff. So we have a lot of stuff to do today then, I guess. Because we have to read. I'm not going to read. By the way, if you're wondering, I am not reading this entire plan. It's 2,700 pages. I'd rather. No, definitely not. But we are reading what's happening here. The Senate also voted 68-29 to limit further debate to a maximum of 30 hours, setting up a potential vote on passage early on Tuesday on the package. So we're going to hear either tomorrow or the day afterwards, right? At maximum Wednesday. If they have a 30-hour maximum from right now, for example, I think it actually might conclude tomorrow then. No, maybe 2 days. No, to be honest with you, I think Wednesday is the maximum, but most likely tomorrow we'll get a result on this. The massive spending bill is popular among many lawmakers in both parties because of the federal dollars it would deliver to their home states. Polls also show that Americans at large are supportive of it. I don't think they mentioned crypto in here because they never do. But a separate Democratic memo says the $3.5 trillion cost would be fully paid for by a combination of tax increases, saving in federal healthcare programs, that's always nice, and projected long-term economic growth. I guess that's something. There would also be no tax increases for those making under $400,000 a year. Okay, I guess that's pretty cool. The tax increase, which already been previewed by the Biden administration, would hit high-income earners and would be coupled with beefed-up IRS enforcement. The measure also calls for a carbon polluter import fee. All right. The Senate worked a second straight weekend, wow, what a job, right, to advance their infrastructure bill aimed at repairing, spending, and improving roads, bridges, waterworks, and schools. I thought they meant it, in a psychological way, but no, they mean it in a real way. They are working on schools and whatnot. But I don't think they mentioned crypto in this because they never do. If the $1 trillion bill is approved by the Senate, as expected, the House would still have to debate and vote on it sometime after it returns in late September from its summer break. Wait a minute, what? So tomorrow or the day afterwards, it could be approved by Senate, and then the House would have to debate on vote on it, which could take another month and a half. Okay. Yeah. Guys, we have any questions? We have any other conclusions that I missed? Otherwise, we're going to go over onto the Ripple news that we have. But I just quickly wanted to know if there's anything I missed about this bill. Because as it currently stands, there's been a new... Okay, so the $1 trillion thing is going to be voted on tomorrow. And then together with that, they're also going to be basically debating about a $3.5 trillion bill. The crypto thing has the crypto amendment has come to a good conclusion. And yeah, I think that's what we got for right now. Basically nothing special. This is actually a lot more special than you might think. This is actually a lot more interesting than might meet the eye. This is a really big announcement, really big thing. You'll most likely see also the amount of people knowing about this or talking about this as something quite significant. This is a big deal. Really big deal. Try to find out the details of the bill for crypto, dude. How can we find that, though, guys? How can we find the latest amendment? Okay, let's type in Rob Portman, crypto amendment. No, I can only find it from 2 days ago. 27 minutes. Okay, let's see here. No, that's Rob Portman himself. Guys, if you know where to find the official amendment right now, send it to me over on Twitter. I will read it through and I'll give you guys an update later today. Right now, I'm not able to find it, and I want to cover the Ripple news for you guys as well. Because I'm checking everywhere out, but I only see 2 days, 3 days, 2 days, 3 days. And I'm also not sure how the websites work for that. I have no idea on what website that would normally be on. Somebody says, I hope this bill does not pass because there's too much control garbage hidden in the pages. Fake news states most people want this. Hard rock bullies. That's actually really difficult because it's 2,700 pages. And so every single time a bill like this goes through, there will be a lot of shady stuff which passes. But that's just the way that things go. And this infrastructure bill might not be nice, but you can't do anything about it. All you can do is call your senators and maybe, ask them to amend something. But yeah, that's basically it. Estimate on settlement date. We do not have that. Okay. If you guys find anything, make sure you send it to me over on Twitter. I am checking everything out. Or make sure you send it to me over on Discord. I'm checking everything out. Let's move on with the Ripple news right now until anybody sends me some other stuff that I didn't know yet. All right. So that's going to be interesting. All right. So let's also change the title again, I guess. I'm not sure. No, let's keep it with this title. It's fine. No, I don't know what the title was at first anymore. I'm going to quickly change back the title because we're going to change our subject and then we'll talk about it. All right, there we go. Let me take everything. There There we go. Okay, I'm going to quickly change the title for 5 seconds. All right, there we go. Yeah, perfect. All right, change the title. There we go. Let's cover it. So, just came out about an hour ago now. Let's quickly check it out. Now, plaintiff SEC respectfully requests a pre-motion conference where the SEC will seek an order compelling Ripple to search and produce relevant communications between Ripple employees on Slack, a messaging application that a Ripple employee testified was a blank. And this is what they very often do. It's just hidden information. So even though Ripple, obviously, and the court get to see what it says here, once the letters are posted to the public, basically, we cannot know what the Ripple employee testified on. Which is actually interesting to me. A Ripple employee testified? What about? All right, what did he do? How does that work? I have no idea, but it's interesting. Ripple agreed at the outset of discovery to search for and produce responsive Slack data, but now, in a waning days of fact discovery, suddenly refuses to do so on the basis that Ripple's mistakes in gathering that data. Yet, the relatively few Slack messages Ripple has produced have yielded critically important information, not contained in emails or other documents that the SEC has repeatedly used in depositions to refresh Ripple's employees' dwindling recollections. The parties have met and conferred as to this issue and are at an impasse. And I really wonder, guys, and you have to start the... guys, I messed up my freaking wisdom tooth. Okay, never mind. I cannot scream. Oh, I messed up a little bit. That hurts like a mother trucker, man. I told you guys about the wisdom tooth extraction, right? First two, splendidly. The other, I guess, third one went splendidly. The fourth one, it's hurting. It makes a grown man cry, almost. I guess not really, but damn, is it annoying. But point is, you guys gotta think with me here. How dumb is this? How dumb can these guys be? Ripple has shown to the judge, hey, judge, the SEC is not giving us the information that they need to. Right? We've met and conferred, and they keep saying, oh, we'll give it, but they never do. And now all of a sudden, the SEC is saying, oh, Ripple hasn't been giving us the info. We're talking about a couple of Slack messages. And even though that might be important, if the SEC has been withholding every single piece of information regarding Bitcoin, Ethereum, and XRP, I think that's about 1,000 times more important. That's just my own opinion, though. So I don't know. I don't understand how the SEC isn't self-incriminating here, because what they're doing is just basically putting up a stage for Ripple to say, hey, all right, you want, let's say, about 1,000 messages. We want about 80,000. So bring it up then, you know? And let's put a date on it. They're going to get themselves in so much trouble for this one. I have no idea. I don't understand. But right, on July 1st, the SEC first told Ripple that the SEC believed Ripple's production of Slack messages was incomplete. 1 month later, on July 30th, after repeatedly contending that its Slack production was complete, Ripple admitted that due to a data processing mistake, Ripple had only collected a small fraction of Slack messages, and that a massive quantity of Slack data had not been collected or searched. Which is, from some perspective, understandable. I mean, you can always try to hide info, that's one thing, but you can also make mistakes if you're trying to get, let's say, about 150,000 pages worth of stuff. It can be that you lose, for example, 6,000 pages worth, right? If you're trying to look at 150,000. Because we're looking at it now percentually wise. I mean, 6,000 pages is a lot of things, but 150,000 pages or documents, for example, and I think it's pages, I'm not sure though, it's significant, you know, so, two things, although, by the way, did you get Link to come here, Fullerene? Hey, Fullerene, what's up, man? Two things, I guess. One is we have not heard anything about William Hinman, which is odd, because we thought they would get into some discussion about it. And second of all, we have not heard anything about Ripple's... No, we have three things waiting for. We have not heard anything about Ripple's, basically, attack about their motion to strike, because there was a big debate about their motion to dismiss due to the William Hinman deposition and some of the statements from SEC members, yet Ripple didn't ever give their final report out, which is also odd. Jeremy Hogan also posted on that, and I also posted on that. And then the last part is, I guess, weird that Ripple never continued on their missing SEC documents. I don't understand why, but all right. Let's quickly check it out. Ripple now refuses to search the full set of Slack messages for any of the 33 custodians whose records the parties agreed to search and produce. other than the individual defendants. Ripple's data error and refusal to produce most documents has already been highly prejudicial to the SEC. Among other things, the SEC has deposed 11 Ripple witnesses. I never even knew that, right? Did you guys know? The SEC has actually questioned 11 Ripple witnesses using incomplete records of their communications. So, two-parted. One, I didn't know that 11 Ripple witnesses or employees or something along those lines were deposed. They were basically questioned, interrogated, whatever you want to call it. And also, I did not know, I guess, that was done with wrong info, which is definitely annoying. So, I got to give that one to the SEC, right? That's kind of annoying. Now, for the reasons set forth below, Ripple should be compelled to search and produce responsive messages from 22 of its email custodians. And by the way, wondering how the price is going right now. Okay, nothing has changed in the price for the last couple of minutes. Okay. Interesting. Okay. Factual background. From the outset of this case, Ripple has known that its Slack messages contained highly relevant communications that the SEC was looking for. Even before the SEC filed its action in December of 2020, while the SEC was still investigating Ripple's violations of the security laws, Ripple was on notice of the importance of its Slack communications. During his investigative testimony, David Schwartz, so he's also been I didn't even know that was something that happened all the time, guys. Even though that, he had an investigation and he had a testimony. David Schwartz, Ripple's CTO, and one of its first and longest tenured employees testified that blank. We want to know. But I guess maybe he just said something about the Slack communications being important. Not exactly sure. Somebody says you're going to pay for screaming and hurting your wisdom tooth surgery area. It'll hit at 3 a.m. Use something new, natural to help you sleep to head it off. And the SEC, it's all a show. I'm going to feel that indeed in a couple of hours. I'm already regretting my mistake from just now. But yeah, it's all, man, I feel this is all kind of a joke, but all right. Well, let's continue on. I want to really know what David Schwartz testified, but of course we're not going to find out. A. Schwartz in testimony tour at 265.10. I guess it's just the specific part of his testimony. Okay, never mind. By August 2020, Ripple had begun collecting and searching Slack communications at the SEC's request, but suspended those efforts after the SEC staff issued Ripple a notice of the staff's intent to recommend an enforcement action against Ripple in September 2020. Wait, okay. We're actually getting quite a lot of info that I've never had before. So, let's see this. Let's investigate this one. By August of 2020, Ripple had started looking through their Slack communications at the SEC's request. Okay, so in August of 2020, the SEC requested Ripple to look through their info. And then that was because they got a notice of the staff's intent to recommend an enforcement action against Ripple in September. So Ripple knew about the lawsuit, I guess, in September already, right? That is interesting. I didn't know that too much, that they knew about it so many months before. Okay. So, on January 25th, the very first day of discovery in this litigation, the SEC's first request for production of documents was that Ripple resume its search of Slack messages for responsive documents. Ripple explicitly agreed to search all communications, including Slack messages, for the relevant custodians as to the SEC's requests for production. Indeed, Ripple admits that it controls the corporate Slack account, and so they could have done it. And they made a mistake somewhere. Somebody says a biblical, I can't pronounce that, crash is coming because okay, never mind. Let's not cover that. On June 21st, 2021, Ripple produced what the SEC expected would be the last significant set of Slack documents consistent with the party's plan. That Ripple, this is B, by the way. So this basically means Ripple did go through a lot of its stuff, but they didn't go through it all, or at least not enough of it all. On June 21st, Ripple produced what the SEC expected would be the last significant set of messages, consistent with the party's plan that Ripple would mostly complete productions approximately 2 weeks before the original fact discovery deadline of July 2nd. 10 days later, on July 1st, the SEC alerted Ripple that the SEC believed, given the small number of produced Slack messages involving individual defendants Brad Garlinghouse and I guess that's it, that Ripple's production of Slack documents was not complete. And that is actually to be seen in some emails dating back to July 2nd. Over the next 3 weeks, Ripple repeatedly dismissed the SEC's concerns, insisting that Ripple's review of Slack documents was complete, and that Ripple had undertaken comprehensive searches for all responsive Slack messages, and that Ripple did not see a basis for the SEC's concern. The SEC nevertheless persisted in its efforts to obtain a complete production. On July 23rd, nearly 6 months after the SEC had requested Slack documents from Ripple in this litigation, the company finally conceded that the SEC's suspicions were correct. Ripple represented that due to an error in its document collection process, Ripple had not gathered, let alone searched, many Slack communications involving Garlinghouse. A week later, on July 30th, Ripple revealed for the first time that the full extent of its production failure. Ripple had not only failed to properly collect and review all of Garlinghouse's Slack messages, it had also failed to collect and review, as to all 33 designated custodians of Ripple's documents, direct messages between two people, multiple party instant messages, messaging among multiple people, and chat messages posted on channels open to all Ripple employees, together the missing documents. Ripple admitted that the missing documents amount was very substantial volume of additional Slack data. While Ripple had collected 82,000 conversations, each with many messages. Holy smokes, guys. Oh, okay, wait a minute. You guys saying refresh? Okay, sorry. I mean, guys, give a man a second. I'm not always instantly. I try my best. Let's see. We got a update. You guys are saying update? Okay. I got you. Don't worry about it. Check it out. Ooh, okay. This is 3 minutes ago. Let's see. Breaking. Parties tee up deliberative process privilege dispute with respect to documents withheld by the SEC based on the SEC's assertion of the privilege. Filed joint request for 8-page letters addressing issue. Wait a minute. I have no idea what it just said. Breaking. Parties tee up deliberative process privilege dispute. Okay. This deliberative process privilege dispute actually goes back to the William Hinman deposition, because the SEC basically said all of this, what you wanted to ask Ripple, all of that you wanted to ask, that actually falls under privilege, which basically means you're not supposed to get it. And the SEC wanted to kind of conclude that. I don't know if they wanted to conclude it prior or after anymore, and what Ripple wanted, but they basically had different time frames when they wanted to conclude that. But they basically concluded eventually that it had to be discussed after the William Hinman deposition. So they're now teeing up. Okay, let's see. On behalf of defendants Brad Garlinghouse, Chris Larson, and Ripple Inc., we anticipate filing a letter request for local rule conference. Oh, wait a minute. So Ripple also wants a conference, or wait a minute. We anticipate filing a letter request for a new conference to address a discovery dispute between defendants and the SEC regarding the latter's assertion of delivery. Yep. So there's 2 hearings coming up. Wait a minute. Oh, holy smokes. Regarding the latter's assertion of deliberative process privilege with respect to documents withheld in its litigation. The parties have conferred and believe that the modest page limit extension would facilitate the presentation of these issues for the court's consideration. Or are they just trying to get 8 pages instead of the usual 4 or something like that? Let me see. Let me read through it first. We therefore respectfully request that the court grant the parties leave for each defendant and the SEC to file 8-page letters, and 2, for the SEC to have 5 days to respond to the defendant's letter. We are available to respond to any questions the court may have. By Matthew Solomon. Oh, my head is exploding from information. Wait a minute. I have to get this through my head. I say holy smokes a lot. That's true, man. I say that quite often. So they're saying we want to defendants and the SEC can file 8-page letters about the dispute between the SEC and Ripple by deliberative process privilege, which is basically just the fact that a lot of the information is privileged. Like, for example, the letter that William Hinman put up, right? Or am I getting that wrong? Okay, somebody asked what did I miss? A lot of stuff. And by the way, guys, we have 1,100 people watching. If you're watching this far, make sure you press that like button. We can get to at least 500. I do my best of my best to make sure I'm here first. You can see it. We just got breaking news about 1 minute ago. And we're already here covering it, even though we don't know everything. We're not lawyers, but we try anyway, right? You know what I mean? We try. And you guys are also amazing for tagging me so freaking quick and all this stuff, man. Look at this. I'm going to like you guys all. Big shout out to Crypto ML7. XRP, I follow you. XRP will be fine 1 and Redbeard. Big shout out to you guys. Patch says, I think Ripple are dropping SEC liner saying that's privileged. No, okay, never mind. That's wrong. You know, to be honest with you guys, this is actually one of the more confusing parts. I've actually not had that before. But as it currently stands, I believe they want to file a second conference, right? At least that's as far as I know now. They want to file a second conference, and they're giving the SEC 5 days to respond. And they can both put up a letter of about 8 pages saying that they want to get this done. They basically are anticipating that a conference is going to pull through, but they might be able to conclude it by filing this letter process. And I think how the letter process usually works is that Ripple, for example, puts up 8 pages now as to why they think they are due a something. For example, why they think that this deliberative process privilege is BS. They put up 8 pages for that. The SEC responds with 8 pages, and then Ripple gets to reply one more time to explain why they do think it's so. And if they do not come to a conclusion, then they basically they file for a conference. But that's what I think. That's what I got from reading this. Once more, guys, I am not a lawyer, not any advisor in that regard. So I would be pleased if anybody with actual legal knowledge can help. Let's once more read what he said. The parties tee up deliberative process privilege dispute with respect to documents withheld by the SEC based on the SEC's assertion of the privilege. I get that completely. That basically just means they right now are squaring up. You know, they're standing in front of each other to discuss about all the files that the SEC has not given out because they say it is privileged. And privilege basically just means that because it's from a higher up person in the American, court basically, or in the American, hierarchy, they don't have to give it out because it's the same thing as the privilege, but then in a different sort of privilege. If you talk with your psychiatrist, he's not going to tell everything to the police. Unless you're going to say you're going to, get somebody, then they might do that. But generally speaking, they don't on the same type of part. And the last part here says the file joint request for 8-page letters addressing the issue. So, yeah, okay, no, we get it, guys. It's pretty simple. They're just going to have now an 8-page back and forth about why the SEC should give out their documents, and the SEC is going to reply saying why they shouldn't. So, it's not that difficult. Easy. All right, don't worry about it, guys. You know Dusty PC has got you. If there's ever any news like this, you know the Dusty PC channel has got you, and that is why. If you are an XRP holder and you're not subscribed to this channel, I think you're missing out. I'm just quickly putting it up there. I honestly think so. What other channel is here as quickly as this? So once more, guys, if you don't know how the letter works here, Ripple and SEC are going to discuss the privilege issue because the SEC has been withholding a lot of documents. And I think that Ripple was actually waiting for a very long time until the SEC filed another complaint so they can catch them off guard. Okay, we got another update. Somebody says check out the Senator Loomis bill. Guys, this is a really interesting live stream. Senator Loomis. Okay, I'm typing it in. I'm typing it like a freaking madman. You know that? Okay, so there's 2 parts. I see Senator Loomis. Let's actually read what she said yesterday first. I'm going to have to make a lot of freaking update videos later today because I have to clarify everything in separate videos like I always do, so don't worry about it. I got you, though. Yusper says, isn't Ripple saying that the documents filed by the SEC is incomplete and they want some time to add these missing things, referring to the document filed earlier? Honestly, Yusper, I don't think so, but it could be. Once more, I'm not a lawyer. But what I think is that Ripple is now addressing the fact that the SEC has been hiding documents, right? Because they're not really saying anything about them hiding documents. And it's also not really as if they're talking about their deliberative process privilege. Or are they? No, I think it's about the SEC's assertion of deliberative process privilege, which refers to the issue at the William Hima deposition too, that the SEC thinks that most information is privileged. I don't think this regards to Ripple's privilege, which, for example, would be the Slack communications. I don't think so. Okay, let's quickly check out Loomis. Did she tweet anything out just now? Yeah, 25 minutes ago. Okay, we've been working all weekend to come up with a compromise to address the digital asset broker issue in a bipartisan infrastructure framework. While it's not perfect, it protects innovation and doesn't choose winners or losers. That is ultimately what we wanted. So that's beautiful. Today, we're going to push for a unanimous consent agreement on the Senate floor, which we are hoping is going to be a success. And while there were bumps in the road, this is how the Senate is supposed to work. Thanks Ron Wyden, Senator Toomey, Mark Warner, Sinema, and Rob Portman for their hard work and open minds on this issue. Open minds is relative, but I guess that's juicy. Let me quickly like you as well, Anna. Next Kryptonite, I'll give you a follow back because you shared that with me. I appreciate that a ton. For all of you sharing those things with me, thank you so much, man. I appreciate it because we can get the news sooner if you guys do that type of stuff. But what a day today, guys. What a day. Wow, I'm at awe a little bit. But that is really good because if the infrastructure bill passed prior, it would have been extremely negative. What with this though, it makes everything so much better. So this is finally I can sleep. I've been thinking about this for so long, guys. Last couple of days it just caught me. Unfortunately, this kills innovation in DeFi. Wait a minute. Where small lenders and liquidity providers could already report and pay taxes, but can no longer lend or liquidity provide without being considered brokers required to file information they don't have about recipients. I'm going to say maybe it's actually not as inclusive as we might hope, because it says right here, any person who, for consideration, regularly effectuates transfers of digital assets on behalf of another person. Yeah, I mean, that, I don't know. It's going to be quite a kind of vague, you know, so let's not cover that one too much. I'm not wasting my time on this one. Guys, today has been a really good day. It has been a beautiful day. Only good stuff. You might say the SEC stuff is bad. It isn't. They're self-incriminating. They're dumbasses. Oh, I shouldn't say that, but I don't think they're doing really smart stuff. Should we continue, however, to talk about this first bill? Once more, don't worry about it, guys. I will make sure that everything is clear to you all. I'll make updates about every specific part. So, yeah, so don't worry about it, all right? I got you. I'm quickly banning somebody from the Discord. Give me 1 second. How do I ban him on my phone? I'm not sure how I ban people on my phone. Never mind. I'll just delete the message then. Okay, there we go. I just wanted to quickly make sure nothing crazy was said in the Discord. So you just had to delete one thing. Okay. Fullerene, are you also on Discord, by the way? Because I can give you mod in Discord as well if you are. Because I like your moderation efforts, man. You're doing a freaking great job in the freaking YouTube comments, man. All right, let's move on though, guys. Because this was the initial report, and once more, I'll make updates about everything in a really easy 10-minute video, most likely later today, to make sure you guys all get it. Ripple admitted that the missing documents amount to a very substantial volume of additional Slack data. While Ripple had collected 82,000 conversations, each with many messages, which is actually awful. That is awful. Reviewed more than 7,000 of those and produced 1,400 of them. Okay, so the missing documents consist of well over 1 million messages, comprising terabytes of data. The Slack messages, in other words, are an information set whose size eclipses that of Ripple's large email productions, corroborating testimony that Ripple employees communicated at least as often by Slack as by email. The federal rules of civil procedure, which do not distinguish between emails and other forms of written communications, effectively require Ripple to collect and search this critical repository of data for responsive communications involving the same 33 custodians whose emails Ripple has already agreed to search. So, nevertheless, to reduce Ripple's burden and expenses, the SEC agreed that Ripple can limit its search of Slack's messages to 22 designated document custodians. The 14 Ripple deponents plus 8. This is a C, but I assume it means an 8. No, okay. If you zoom in, it's actually an E. Wait a minute. That's pretty funny. Huh. Okay. Individuals from Ripple's original email document custodian list. based on those custodians' roles at Ripple. So the SEC wants 14 of Ripple's employees, which have been questioned, I think, plus the messages about 22 custodians, right? I believe so. Yet, irrespective of its previous agreement regarding relevant email and Slack custodians, Ripple will only agree to search the Slack messages of the individual defendants and the direct messages and multi-party instant messages of 6 other custodians, which Ripple selected based on the frequency with which they used Slack. Okay, so Ripple's saying, nah, we don't want to do that. We're only going to give you a little bit. There's also an Excel sheet of Slack usage by custodian. In other words, Ripple agreed to search the documents of a fraction of the custodian whose emails and Slack messages contained highly probative evidence. Yeah, okay, I get it. So they're just saying, once more, Ripple, get us more information. This is not a really difficult part. It's just, I guess, annoying. It's just a back and forth between the SEC and Ripple. We can't really be on Ripple's side here or the SEC side, because even though a million messages is a lot, the SEC has already compromised saying, no, we just want a couple less. Yet, I guess it's good because the SEC has kind of got the upper hand here because Ripple's not giving information over. Yet, Ripple instantly filed another letter saying that the SEC is doing the exact same thing, right? So, at least that's what I fetched from this. The relatively few Slack documents Ripple has produced so far demonstrate that missing documents are necessary for the SEC to build a complete and accurate record for summary judgment and trial. The messages produced show Ripple employees, including custodians whose Slack messages Ripple refuses to search, discussing issues directly relevant to the disputes at the heart of this case. The messages include a discussion. Okay, so this is what they're looking for. That's actually kind of important. The messages include a discussion about Ripple's desire to create a speculative trading in XRP. So that's what Ripple wanted to make, and the SEC has reason to believe that that is what is in there. That's interesting. That's because of a compilation exhibit with highlights of relevant portions added by the SEC. Then the effect of Ripple announcements and efforts on and Ripple's concerns as to the price of XRP. Then the relationship and central importance of XRP sales to Ripple's overall business and the regulatory status of XRP. So definitely it is quite important for the SEC to get this information. We cannot deny that. The missing documents not only may be admissible at summary judgment and trial, but are likely to refresh Ripple's employees' recollections at trial. During their depositions, Ripple... So, I really am confused. I didn't know they were all deposed like that. I never knew that. I guess maybe it's normal, right? But I never knew. Ripple employees frequently testified that they did not recall many critical facts. For example, Ripple's former CFO, Ron Will, stated that he did not recall events in response to over 250 questions. Ripple's head of investor relations, Monica Long, did not recall answers to over 150 questions. Brianne Madigan, who headed Ripple's XRP Global Markets team at the time of her deposition, and whose missing documents Ripple refuses to search, could not recall answers to over 150 questions. 15. However, the SEC was able to refresh witnesses' recollections using Slack messages. Had Ripple properly searched and produced all responsive Slack messages, the SEC would have almost certainly been able to refresh the recollections of other deponents. In any event, the SEC needs the relevant missing documents, at least for summary judgment and trial. This is about to get really interesting. So, then point number 2 of this one. Ripple should be required to search the Slack messages of 22 of its 33 custodians. And I think that's actually only one more page, right? About a page more. Okay, so one more page, then we're done, guys. So, Rule 26 is proportionally factors addressed below weigh heavily in favor of compelling Ripple to search the missing documents and produce responsive, non-privileged Slack conversations for at least 22 out of the 23 custodians. It had already agreed to possess relevant documents. Discovery should be proportional to the needs of the case, taking into account the amount in controversy, the party's relevant access to relevant information, the party's resources, and the importance of the discovery in resolving the issues and whether the burden of expense of the proposed discovery outweighs its likely benefit. Ripple could not have originally credibly refused to search and produce all the relevant, responsive electronic communications for the 33 custodians, despite the burden and cost in a case of this scope. Yet, in the last month of fact discovery, and based upon its own failure to meet its discovery obligations, Ripple has walked back its agreement to search communications for all custodians and refused to search and produce the relevant Slack messages. Simply another form of electronic communications that Ripple employees used routinely. The court should not permit Ripple, after months of lulling the SEC into thinking Ripple would produce relevant Slack messages for all 33 custodians, to unilaterally, and at the 11th hour, limit the number of custodians whose missing documents Ripple will search and produce, and to leave the SEC and the court with a plainly incomplete record of most custodians' communications. The relevant missing documents are necessary for a full and fair trial in this important case. First, in part given the significant amount of controversy in this case, the court has noted that this is an incredibly high-stakes, high-value litigation. And I like that wording from the judge. That is pretty nice, right? The judge has understood how important this lawsuit actually is. She has stated this multiple times. One of those times was actually the hearing that we had a couple of months ago already. Now, this is all hidden. I find it really annoying that stuff like that is hidden, by the way. They also say, for example, on one of these footnotes, Ripple's employees were not able to remember a number of important issues. Monica Long, for example, recalled blank, but could not recall which ones. Oh, that's annoying. It could not recall the specifics of internal conversations and could not recall the substance of most of her conversations with Garlinghouse, a frequent Slack user. Ripple's first head of markets, whose Slack messages Ripple refused to search, could not recall the substance of his conversations with Chris Larson, and with Ripple's head of business, Patrick Griffin, whose Slack messages Ripple will also not search, about Ripple's attempts in 2014 to blank. That is so annoying. Rappaport explaining that Larson had views as to blank, but not recalling what those views were. Griffin similarly could not recall blank are the substance of conversations at Ripple about whether there was a blank. Madigan could not recall what other Ripple employees said about Ripple's attempt to blank. Similarly, Ryan Zagone, Ripple's head of regulatory affairs, could not recall the substance of conversations with regulators about XRP's classification under the security laws. That's annoying. That's really annoying. Abi, what are you saying, my man? Second, Ripple is the only custodian with access to the missing documents. It controls the corporate Slack account, which Slack is prohibited under federal law from providing to the SEC, absent Ripple's consent. The SEC has sought Ripple's consent as a way to lessen the company's burden, but Ripple has refused to consent. Third, Ripple has the financial resources necessary to undertake the search requested by the SEC, which may cost several $100,000. Not only did Ripple raise over $1.4 billion as a result of the conduct at issue, but Ripple continues to raise $150 million a quarter from more XRP sales. And they're talking about the Q2 report here, which is pretty interesting to me. While having no fewer than 7 insurance policies at its disposal to cover legal expenses, indeed, Ripple is represented by at least 14 attorneys from 2 sophisticated law firms. Fourth, the responsive missing documents are critical to presenting an accurate and complete I like this part though. An accurate and complete factual record on summary judgment and at any trial, allowing Ripple to, on the last days of discovery, walk away from its early agreement to search all relevant communications and continue withholding relevant messages from the missing documents that will deprive the SEC of the most, they changed the tone, of the most critical repository of evidence on several key topics, and will permit Ripple to benefit from its own data collection errors. As one court has noted, electronic messages between a party's employees may be one of the most compelling forms of evidence, due to the fact that the case of sending or replying to such messages can cause people to say things they might not otherwise say in traditional correspondence. Indeed, they are often replete with unrehearsed, spontaneous statements that surpass in simplicity and frankness and ease of understanding other far more complicated bits of evidence. Simply stated, electronic communications have the potential to provide the proverbial smoking gun, ordering defendants to conduct an additional thorough search for instant messages in any format and text messages between defendants that relate or refer in any way to the plaintiff or these allegations in the complaint. Let's see. ordering defendants to search for and produce Bloomberg instant messages in litigation involving $40 million loan. Okay, they had to do that back in the day. Okay, I see. And fifth, the burden of producing. Okay, I can't even remember what these 5 points were now, by the way. We're just reading them as we go, and I'll remember if I read it again. The burden of production does not outweigh the benefit. Ripple's failure to search and produce the responsive missing documents has already prejudiced the SEC's ability to obtain relevant deposition testimony from Ripple employees who have been deposed. Ordering Ripple to produce all relevant missing documents is necessary to mitigate any further prejudice to the SEC. The Slack messages can be used at the upcoming depositions of the individual defendants, on summary judgment, or wait a minute. So, that's actually a statement we haven't heard before. The SEC is going to depose Brad Garlinghouse and Chris Larson. I didn't know that. On summary judgment or at trial as substantive evidence or to refresh witnesses' recollections. Ripple's proposal that it search only part of the Slack messages of 6 custodians, plus all the individual defendants' messages, is not proportional to the needs of the case. The frequency with which one employee used Slack does not equate with relevance. A Ripple employee who uses Slack less frequently than others may very well have sent or received highly relevant messages, and the SEC's list of 22 custodians, as explained above, is narrow, targeted, and calculated towards relevance, which is basically to overcome that burden of it is more important than the effort is there. In sum, the benefit of searching the missing documents for responsive messages is significant and outweighs the burden that the search will impose on Ripple, and the search and production will ameliorate the prejudice the SEC has already suffered. Ripple should not be permitted to reap a reward from its discovery mistakes and refuse at the last minute to search for the documents it long ago agreed to search. The court should therefore compel Ripple to gather, search, and, if responsive, produce the missing documents as expeditiously as possible. And then there's about 70 pages worth of, 70 pages worth of just evidence, basically. I'll zoom out a little bit and show kind of through it. Exhibit A, filed under seal, so we can't get to see that. Exhibit B, filed under seal. Exhibit C, we can actually see that one. It's basically emails going from the SEC to Ripple. This is basically, and this is what you're going to see for a very long time. All right, it's basically going to be the SEC for a very long time explaining how they have asked Ripple about these communications and how Ripple responded to it, and some of the prior lawsuits, for example, and all that stuff, all the stuff that is necessary. Yet, I find there's actually so many different little bits of knowledge that I didn't actually have. For example, XRP means the digital asset, tokens, or coins known as XRP, previously known as Ripple credits or Ripples. I didn't know they were ever called Ripple credits. Did you guys know that? That XRP's previous name was Ripple credits. I did not know. This is just some wording about what it all means. It does not matter. Wait a minute. Hey, all documents and communications concerning Flare networks, including but not limited to Flare's distribution of Spark token to XP holders. They actually want that as well. Okay, that is pretty interesting. All documents concerning Ripple's efforts to generate positive news with respect to Ripple or XRP. That's a lot of work. By the way, I really hope I never get a company this big where I can be sued for this much information, because I'm already tired just looking at this. Guys, can you not understand? If you have to look through millions and millions and millions of messages and thousands of hundreds of thousands of emails, which again are millions of messages once more, I'm already feeling tired just thinking about that. What a burden. What a burden. There's so much that they're looking for. All documents and communications concerning Ripple's efforts to purchase XRP or otherwise limit the supply of XRP in the secondary market, including but not limited to communications with any person, including but not included to or limited to SBI Holdings, GSR Markets, and crypto systems. There's so much stuff that they want. There's so much stuff. 38 different pieces that have just... Okay, so conclusion, by the way, because I think we can conclude it for now. I don't think we have too much extra info. We can look through this for another hour or so, because it's just, again, it's about 50 more pages of just back and forward, most likely. The conclusion here is that there's a couple of things which came out today. And don't worry, guys, I'll make separate videos about all three of these subjects, most likely, throughout the day somewhere. So, first of all, we had a document from the SEC in which the SEC basically requests Ripple to look through millions of messages because, well, they didn't do it properly before. With the basic underline being, you should have done it before, you didn't because you said you gave everything, yet later on we noticed you actually did not give everything and you just made an error. That's what Ripple said. So now give it to us because we need it. We've already been prejudiced by you not giving it earlier, but even now we can use the info, which is going to be all the messages regarding to Slack. Then the second part is revolving around the new document, which was just posted. And that basically revolves around Ripple requesting a new... These were both, I think, calls for a hearing, right? Yeah. So these are both calls for a hearing, which basically means, at least that's what wait, a pre-motion conference. Does that mean a telephonic hearing? I do think so. I do think so. But maybe that just means a back and forwarding conference. I'm not exactly sure. Maybe this just means a pre-motion conference. It basically just means they talk back and forth before anything officially comes out. That might also be it. So don't quote me on that one. And this one was, we anticipate filing a letter request for local Rule 37 conference to address a discovery dispute. This basically just means Ripple and the SEC, that's again on request of Ripple, are going to go back and forth about whether or not the SEC has to give over certain documents. So those were the two things regarding the law which came out today. And then the third part, which was rather big as well, was the infrastructure bill. Two neat things. One is the proposed $3.5 trillion follow-up and the conclusion of the amendment. So Rob Boardman and Senator Loomis, for example, came to the conclusion of a better bill that we all wanted to see. And that was also something that just came out about an hour ago or so when we started the stream, basically. So even though it's not completely inclusive, it is a little bit better. You guys keep saying check your notifications. Okay, I will. Let's quickly check it out. 6 minutes ago. Jeff Steen says, can confirm Treasury was consulted on this crypto agreement and does not oppose. Okay, that's Jeff Steen who earlier said, here's the text of the new crypto agreement. Assume someone has already tweeted this, but need to make sure my followers see it as well. I'll retweet it too. You know what, guys? Make sure you press the like button right now. We have 1,000 people watching. There's been 12,500 people who watched this stream this far. I can show you guys that. I will not do it for right now because it's a little bit annoying to get it in. But about 12,409 people have pressed this stream on. Yet we only have 600 likes. Let's get to 1,000 likes right now. I'm not sure if we can do it, but if all of you watching right now press that like button, we'd instantly bet 1,000 because a lot of you guys right now watching have not pressed it yet. Let's see if we can actually do it. I've never had that before, that we have more likes than viewers, but we can't do it right now. Make sure you press that button to help out. Right now, just press the like button. I'll wait for you. Okay, it's not working. But I tried though. Let's quickly check this one out. So this is the new definition of a broker. Nothing in this section or the amendments made by this section shall be construed to create any inference that a person described in this section of the Internal Revenue Code of 1986, as added by this section, includes any person solely engaged in the business of, solely engaged, validating distributed ledger transactions without providing other functions or services, or selling hardware or software for which the sole function is to permit persons to control private keys which are used for accessing digital assets on a distributed ledger. Brokers and treatment of digital assets. Nothing in this section or the amendments made by this section should be construed to create any inference, yada, yada, yada. Whether any person is a broker under section 6045 of the IRS, or IR code, whether any digital asset is property which is specified security under section 6045. Well, I mean, that's good but not good because this is actually really vague. I'm a little confused. This is not really that inclusive. I'm also not sure about the wait a minute. Because I'm a little bit confused about this actually. It's not really that inclusive. Or is it too inclusive? Somebody asked, what about developers? Liquidity providers still completely unworkable and unacceptable. And it says here, or at least this guy says they need to start paying taxes. Stake says, so now node operators are exempt, but not miners/validators, since they provide an extra service beyond validating transactions, which is defining the order of those. And crypto software developers still aren't exempt. This still sucks. I'm actually confused about that. How could that be? How could miners, because they explicitly stated that it would exclude miners, right? Stakers, miners, or other non-brokers are excluded, Rob Portman says. And Senator Loomis also was pretty excited about it, so I'm not sure how that could be then. Let's see if any of you guys tagged me in anything still. 9 minutes ago, we already checked this one out, I think. Yeah, we do want that. Reset date, Pacer. Nothing. Watching this BC live right now, getting all the news for the Ripple v SEC case. Yeah, I will give you a follow back too. I appreciate that. Bella says, this is good news for crypto. At least there is an agreement on reasonably tolerable amendment by the two groups that has pushed different amendments, one of which was not good. That's true. And Ben says, thank you for all your hard work in this matter. You have made the people happy. To Rob Portman. The full details are here. Let's check it out. Okay. So Senator Pat Toomey has shared it. I'm glad to announce that we have all reached an agreement on the amendment that fixes crypto reporting requirements for the infrastructure bill. Senators Toomey and Loomis hold press conference on agreement to fix digital asset reporting requirements. That was 2 hours ago. Ooh, okay. Let's quickly check that out as well. Ooh, I will watch this, but it's 20 minutes long. Guys, are these conferences copyright? Or can I do this? Can you guys quickly let me know? Is this stuff, can I actually cover this or not? Last time I was covering something from like CNN or CNBC. You guys were spamming me in the comment section to not do that. But I'm wondering, is this type of senator stuff, is that copyright free, or is this not even allowed to stream, or how does that work? You don't know? I don't know either. I don't want to get in trouble for showing some freaking senator stuff, right? I guess from a certain perspective, he has put it over on Twitter. But let's be safe. Let's not do that, all right? Let's not do that. Otherwise, what if we lose the channel over just showing one stupid video like that, right? You guys are saying double speed the video. I can't do that. There's no option for it. It's Twitter. You're saying you can? It's public? Just because something is public does not mean it's allowed to put in there. This is public. If it's on Twitter, it's public. I mean, CNBC posts their stuff on Twitter too. Doesn't mean I can still take everything, right? I'm not sure about that. But even the press conference, I guess, probably public domain. This is going to be a difficult one. Because yeah, we have a choice now. Either I'm going to grab my phone and we're going to watch this for 20 minutes. I haven't watched it myself either. Have you ever played anything live on live YouTube from Twitter? Of course, very often. Somebody else says it's copyright, Dusty, don't do it. I'm not going to do it, guys, just to be sure. Right? You never know what's going to happen. Let's not risk our YouTube account over something like this. I also think it's fine. I'm 85% sure it's fine. I've retweeted it on my page, so you guys can check it out on my Twitter. All right, I also press the like button on it. Why not? So once more, everything from today that you need to know is on my Twitter here right now. I've shared the most important things. At least everything that we've covered today is on here. But once more, I will make a couple of update videos today. I need to eat something first, though, guys, because I just drove for 2 hours, about 1 hour, 45 minutes to be exact. Club played Saturday Night Live and didn't get hit. Fullerene, sometimes it's a chance game as well. You know, I've actually covered so much stuff that I think, that I'm not sure about. I'm not going to risk it. You know what? So you guys can just check it out for yourselves, I guess, or just wait and I'll watch it and give you guys an update about what is important out of it, because I'm going to watch it during my food just now. All right, because it's also going to be 20 minutes worth of watching. Well, yeah. You know what? I'll check it out myself. Don't worry about it. If you're not, I'll make that conclusion once more. If you are not subscribed, right now is your last chance, right? Make sure you subscribe to the channel right freaking now. There's going to be a couple of update videos today. I have so much stuff to tell you guys and so many conclusions to draw. So I'll definitely make sure you guys get it. All right? Don't worry about it. I got you all. A lot of stuff is going to be coming out today. So you should subscribe. You should press that like button if you enjoyed it. And stay tuned for today. Because once more, I think there's going to be a barrage of videos. It might be 6 videos in a day. Who knows? I'm going to do a lot of freaking stuff. A lot of reporting is going to be coming out. So stay tuned. All right? It's about to be really pretty, at least to me, pretty interesting. A lot of stuff is going to be covered. All right? So I'm going to end the stream for right now. I'll get a lot of stuff done. I'm going to have to write down conclusions and whatnot. I'm going to do a lot of research. I'll get back to you guys in like an hour or so with hopefully my first update video. But stay tuned. If you watch the stream, you might not need all of it, but still, it might be nice to refresh your memory because I'm going to do my best. All right, thank you guys all so much for watching. If you enjoyed it, make sure you press that like button and subscribe to the channel. We are actually, guys, we are 6 more subscribers away from 126,000. So if 6 more people subscribe, we are finally getting that threshold. Let's see. 6 more people. Just quickly checking to see if it happens. You guys can see it happen live then. We need 4 more people. Two people already pressed. No, okay, it didn't work. I thought maybe. You don't have to sub, by the way. Once more, some people are saying, stop saying it. Oh, we need 1 more person. 1 more person? I'm refreshing like a madman, but once more. All right, no worries, guys. Once more, the subscription doesn't actually help me either, by the way. It's not like you have to be subscribed. I guess the notification bell does help because I know you guys are seeing it instantly then, which is nice. So notification bell is also important. For the rest, a subscription, it doesn't really do too much. It's just kind of important for you to be there quick, I guess, right? Because some people say, oh, this is old news. And I'm like, yeah, you watched the video 12 hours late. So, yeah. Whatever, man. Hopefully you all enjoyed the stream. I'll see you guys again in another one, all right? So, thank you so much. I'll make sure you guys, I guess, get the info that you need, all right? Don't worry about it. I'm coming back soon.